Okay, I'll start. Good evening. My name is Henning Schulzrinne. I'm a faculty here in the Department of Computer Science. I work on network-related things, architecture, performance, and so on. Until August earlier this year, I had been at the Federal Communication Commission, FCC, since about 2010, on and off, last serving as the Chief Technology Officer for the FCC until that time period. I was involved in the 2010 Open Internet Order fairly in depth, and to some lesser extent in the 2015 order as well.
Hi everyone, I'm Sarah Morris. I am Senior Counsel and Director of Open Internet Policy for New America's Open Technology Institute. New America is a think tank in DC that works on a variety of issues, everything from national security policy to education policy to work-family balance policy, and then of course technology policy, and that's the Open Technology Institute is the technology arm within New America. I will be candid and say that I think I'm surrounded by engineers or people with much more substantive technical knowledge than I am, although I consider myself a fairly technically savvy policy advocate. But I'm happy to be here today to talk about some of the policy implications of what's happening at the Federal Communications Commission right now and into next week. And also to talk maybe about some research that I've done in conjunction with Measurement Lab. Yeah.
Okay. So hi everyone, I'm Vishal Misra. Like Henning, I'm in the computer science department at Columbia University. So my area of research is networking, and it used to be conventional networking, looking at protocols, algorithms, performance. Around 2008 or so, a little bit before that, we started hearing this term network neutrality a lot, and it confused us completely. What is network neutrality? What does it mean? So around that time, prompted by a student, I started learning about economics and relating game theory and economic concepts to conventional networking, topologies and protocols, and started researching internet economics around that time. So I've been working in this area about close to 10 years. And also a couple of years ago, I also got very involved in the Indian net neutrality movement. So I worked both with sort of the citizens pro net neutrality movement. They adopted the definition that I gave of net neutrality. And I also worked with regulatory agencies and the Indian government, providing my input, and so I got very involved with the Indian process. And full disclosure, right now I'm on sabbatical at Google, but I don't speak for Google. Google doesn't speak for me. I don't work on policy at Google. I'm working on conventional networking things, but today I'm speaking as a Columbia faculty and not to a Google person.
And who is also speaking for himself, but thank you for reminding me. So my name is Peter Boothe. I work at Google as a software engineer, and I'm a software engineer on the Measurement Lab project, which is a partnership between Princeton Planet Lab, Google, and the Open Technology Institute in Washington, D.C., where we've gotten together and have a global network of computers that we use to measure the internet. And we make all of our measurements available in raw form, free and available to the public. And we make the process data free and available to the public in an effort to try to encourage, that all the debates can be based on facts, because facts are nice to have.
And I'm Brittney, evening's co-host, and I'm a digital culture correspondent for Digital Village. It's the oldest running radio program in Los Angeles that has been covering the internet for over 20 years. So net neutrality, obviously, you've heard it. The principle is simple in theory, but the bulk definition we're going to use here is that all packets are created equal. So whether I'm at home streaming Stranger Things on Netflix, sending that sad candy gift to my best friend, or opening that email from my aunt asking for computer help, in theory that's all delivered to me the same. Now, the principle may seem simple, but net neutrality sits at the intersection of internet architecture and the equally complex principles of administrative law. So I want to ask our audience, how many of you feel like you fully understand the issues that are technically surrounding net neutrality? And how about legally? well, great. Anyone vote? No, okay, so good. This will be a great panel for all of you. So for the next hour, we'll be delving through the rules as they are today, and going over terms like fast lanes and zero rating, what could change, what the arguments are for repealing net neutrality, and what you, the concerned citizen, can do going forward. So Sarah, I'm going to start with you, and we'll start with what are the regulations that are in place in the United States right now today as we stand?
Right now, today, right this very second, we have the strongest net neutrality regulations on the books in this country's history. They were implemented in they voted on in February of 2015. And they include a few different components, and we can dive into different parts of them as we talk today. But to start, there are three what we call bright line rules. They're just strict prohibitions on certain types of behavior that the FCC in 2015 found to be sort of inherently problematic. So there's a prohibition against blocking, a prohibition against throttling, and a prohibition against paid prioritization. And I assume that's one of the words we'll talk about and define in a few minutes. The Commission in 2015 also noted that some commenters, some people who had been participating in the rulemaking proceeding that was playing out, had noted that there may be other harms besides the ones contemplated by those three bright line rules. And so the Commission also adopted a what they called colloquially the general conduct rule. And so this was a multi-factor balancing test, very similar to a previous rule that they had used to prohibit against discriminatory practices in the 2010 rules, but with a few more factors. And so that was designed as sort of a catch-all for future harms that might either exist at the time that the rules were put in place but might not have been fully yet understood, or which might emerge as harms going forward. In addition, the Commission looked at one specific relationship among different actors in the internet ecosystem, what we call transit providers and last mile internet service providers, and found that they noted that there had been some specific consumer harms that they had seen evidence of in the record, but they declined to implement a rule. They just said, we're going to assert jurisdiction. We find it in our purview to hear about these harms going forward, and we'll reconcile them if people bring complaints, but we're not going to, we're also not going to implement any sort of bright line prohibitions. Importantly, those rules also now extend to mobile, which was something of a departure from the 2010 rules, which only applied to mobile in part. So this resolved what my organization saw as a somewhat absurd result, where if you were in a building like this and connected to the Wi-Fi here, which is, although it's wireless, technically a fixed network with the wireless router on the end of it, and then suddenly walked outside and switched over to Verizon's 4G network, that you would suddenly lose your net neutrality protections. So it treats all networks as equally subject to the rules, though it gave wireless providers, the 2015 rules, which are still in effect, gives the wireless providers some flexibility in how they manage their network, recognizing the inherent characteristics of wireless networks.
So today, can AT&T prioritize my traffic over your traffic if I have more money?
No.
And so can Comcast prioritize their streaming platform over Netflix?
No.
Some networks back when I was in college actually used to block file sharing. So can Verizon prioritize different applications like Google Hangouts over, say, YouTube?
No, that would be a violation
So
of
right
the
now,
rules.
none of that can happen
Correct.
today. Got it.
I'd like to just maybe, not qualify, but maybe to give a wrinkle that always made this discussion more difficult. Both 2010 and 2015 rules had exception for what known as specialized services. And so these were services that were, roughly speaking, seen as IP-based but not internet services. And so, for example, there was some dispute during the 2015 type of, or 2010 type of order duration about Comcast. Since you mentioned Comcast in particular, that their video services would not count towards any quota that they would have, and their justification, which was never resolved in any legal sense, was that it was a specialized service because while it traversed the same infrastructure, it was not a generic internet access service. So I would just say the discrimination issues get a little bit more complex simply because many of these services that are in-house services are not generic internet access over-the-top type of services.
And I would just one thing, when you asked the first question, which was, you said you in the equation, certainly consumers have the ability to purchase better speeds, right? And that's what we want. We want the market differentiation to happen by the service that's offered to consumers. But the idea being that you will get the service that you paid for, and that you'll be able to access the entirety of the internet as a consumer when you make that purchase.
So one of the prohibitive behaviors that Sarah mentioned was paid prioritization, and a lot of the kind of public debate or posts that I've seen on Facebook are about fast lanes. And so I wanted to talk a little bit about what types of fast lanes are and aren't allowed, and what types maybe are and aren't beneficial to the internet. So I've seen claims, for example, that Netflix pays ISPs for fast lanes to access Netflix users who get their internet from the ISPs. I work in internet routing and content delivery, and I know of two types of fast connections that ISPs can offer to companies like Netflix. First, they can let Netflix pay for dedicated connections into their ISP as opposed to having to route the traffic through shared connections. And second, they can pay for servers that have Netflix content on them that are placed inside the ISPs, so then the traffic doesn't have to go over the shared connections at all. So maybe for Henning or anyone who wants to answer this, are these types of fast lanes allowed under the current US regulations? And then are there other types of fast lanes that an ISP can or can't provide to Netflix? Like, how does this fit in with paid prioritization?
First of all, the term fast lane was never one I was particularly fond of, because it has the problem, and we've had a long history in kind of a policy realm of imperfect analysis, the series of tubes that Senator Stevens mentioned a few decades ago, famous for that. Because it has this notion of an express lane, like on I-66, and for the DC folks, given that it has achieved some notoriety for a fast lane.
It's close to home now.
Yes, or other type of arrangements in that. And so, and I think, since we don't have somebody here, so to say, representing, quote, the other side, there has been relatively little evidence that ISPs prioritize within their access network, and you didn't talk about that, but I'm just saying, just generally speaking, for example, give a priority treatment to their own services or paid third-party services. With the exception, I should note that, and that's generally not been discussed much, but it has a competitive implications. If you mention LTE wireless, voice services that you acquire from Verizon or AT&T or T-Mobile Sprint do get priority over third-party, over-the-top Google Hangout, Skype type of services. Again, so that is a, quote, paid prioritization, but it falls under the special services exemption. So to get more directly to your question is, the most likely place indeed for paid prioritization would be the point of interconnection. And that's been a long-running point of disputes going back to kind of a century ago. That interconnection has always been contentious because it provides the last mile provider with a way of monetizing access to their customers. And it also engages, and this is kind of trying to engage the other side of the argument, it often is a not so clear distinction between who is a customer of yours and who is a provider of content to your users. So just as an example, if Columbia University pays a number of internet service providers for access to the internet, But they could also say, we are a content provider that provide content to your customers, and so let us connect to your network for free, because, hey, when we deliver video sessions like tonight to your customers, and so we should be able to interconnect without paying you anything, in which case you kind of just killed the business internet market. So the prioritization tends to be about two things. Namely, one is, do you allow, as you said, a direct interconnection of content distribution networks, either shared ones like Akamai or dedicated single company ones like Netflix, in particular, to run their own infrastructure, and under what conditions. And secondly, to the extent that you connect to transit providers, who pays whom for that privilege, and who pays for what part of the physical infrastructure if capacity needs to be upgraded. And so you can buy those two things. You can make either specific content providers or all content providers potentially pay for access to your eyeball, as they call them typically, customers.
And so to be clear, there aren't currently regulations restricting either of those, either saying that you can or can't offer these interconnections, or dictating to us to pay to upgrade.
That falls under this general notion of particularly interconnection one. So paid prioritization was, she mentioned, outlawed as such, but that largely referred to kind of the intra-network, as it's called, the BIOS, the broadband internet access services, portion of it, not the interconnection part of it. The interconnection part was kind of the, she said, keep an eye on it, and the notion was that if a problem were to arise, then there would be some kind of adjudication on a case-by-case basis. Just having been involved somewhat in that, I was involved in many of the discussions when those problems occurred, and the issues are, there was a fear that simply prohibiting discrimination in and of itself as a blanket discrimination would in some cases lead to undesirable gaming by the other side. I mentioned one, and the other one is that traffic can shift quite frequently and suddenly because of changing business relationship. And this was part of a Netflix dispute of them changing carriers. And so an access provider would suddenly be forced to upgrade connectivity and middle mile connectivity on essentially zero notice, and that would be seen as unreasonable simply because it was unlike actions taken by the ISP, it was actions taken by third parties that weren't quite as black and white in all cases.
So actually that was one of the predictions that our analysis did in 2008, that paid pairing, this paid interconnection will emerge as the primary way for end user ISPs to monetize their customers. So the internet model used to be the commodity that was traded was bandwidth. That was the old model. Now the commodity that is being traded is your customers, the eyeballs. So previously the last mile used to buy bandwidth upstream. Now they are in some sense selling their customers, to the access to customers. Now the internet was designed by, I guess, engineers like us, and routing was what we thought about. But as one very famous economist has said, the internet is about routing money. Routing packets is a side effect. So the whole architecture is about routing packets, and that's where the problem is.
Yeah, it's now evolved to the point where large content providers try to avoid using the shared interconnections whenever they can because of the kind of better performance they can guarantee if they go over the dedicated ones. So Peter, I wanted to ask you kind of a follow-up question about this. I know that MLab has done a lot of work on measuring congestion and interconnections and things along these lines. My perception is that many people interpret fast lanes as meaning that the traffic will get faster at the expense of other traffic. So if Netflix pays for one of these private interconnections and it's considered a fast lane, some people might take that as meaning now it's going to hurt the other traffic. But it seems to me...
And that is potentially possible because there's ability to mark traffic as being in one class or another. Right?
Particularly on the last mile type of paid prioritization, the differentiation that Henning made between paid prioritization or fast lanes on the last mile, and finagling at the point of interconnection.
And so my understanding is that the prioritization in the last mile at this point would be violating the regulations, but one of these direct interconnections, paid interconnections, would be allowed under the regulations.
Well, on a case-by-case basis, I would say. It is not allowed. There's no notion, because it falls under the general conduct rules, and it falls. So
it's
I
not,
would.
It's not restricted. It's not outlawed under the
There is no bright line rule itself, because if you had that, you would have to specify a fair amount of detail as to who is obligated to do what, and that gets into detail that I think nobody wanted to get into at the time.
So the question that I wanted to get at is if Netflix and YouTube, let's say, have direct dedicated connections into a network, and that's maybe half of the traffic going into the network, what happens to the traffic that's left behind on the shared connections? Does it get hurt because of that? Does it get helped? Does it have no effect?
So you're saying that, you're asking the question about what happens when traffic moves from an interconnect, from a shared interconnect to a paid peering?
Yeah, what happens to the traffic that isn't? So for the traffic that isn't from Netflix or YouTube and is still on the shared interconnection, what impact does this have on it?
It depends on whether that interconnect was congested already or not. If the interconnect was congested, it would presumably removing traffic would relieve that congestion, leaving the remaining traffic to do that. Although leaving your interconnect congested, I should point out, would be not great network management practice, but it's happened in the past.
And would be easily remedied.
And it could be easily remedied. Professor Henning Henning discussed the hardware. Just when we talk about interconnections, people frequently draw the internet as a small network and then a long line connected to another small network. But in actuality, when we talk about interconnections between networks, we're talking like 6 to 10 foot cables, and the long cables, both sides are owned by the same entity. So these interconnections are relatively cheap at a hardware level, but they're not necessarily cheap at an organizational or business level. So the traffic, paid peering, if the interconnect is congested, paid peering or shipping a cache could absolutely alleviate congestion.
Okay. And just one last question about these kind of direct paid connections. So another argument that I've seen a lot on Facebook and in the media about this is that it potentially access to these gives large companies an advantage over small startups because they don't have this access and it stifles innovation. So the thing I was wondering is, these days a lot of startups or new companies will deploy in cloud computers owned and hosted by companies like Google and Amazon, and will this then allow them kind of access to the direct connections from these and enable them to deliver services that they wouldn't be able to without those paid connections? What's the kind of interplay between large cloud providers hosting small companies and direct interconnection?
So from a measurement lab perspective, from my perspective when I'm working on measurement lab, because remember, speaking for myself, not my employer, is that our goal is to measure the internet experienced by people. So to the degree that network services are moving to the cloud, our measurement is going to have to move to the cloud as well. It could be said that this move to cloud computing is by forcing all the traffic to go over those Google links or all those traffic to go over those Amazon links, then that solves the problem. It feels a little weird to me to cede that power to and ignore those little guys. I don't know right now the mix of traffic, that is, what percentage of traffic is going which way.
So I think it might be helpful to step back for a second and talk maybe a little bit about the mechanisms by which traffic is routed as a very high level general matter, because I think we've kind of dived deep into the weeds. And they're really interesting hypotheticals, but for the sake of kind of giving a lay of the land. So there's different types of actors on the network. There's people who subscribe to the network, subscribers, all of you here, the university, and you pay a fee for internet access service, and you get internet access service. Let's say you are a startup, and you need to make sure that your traffic, you're something like bigger than just a blog that's hosted on, a blogging platform. Do people still have blogs? I don't know. But you need something like a little bit more robust because you're starting a new video delivery service, and so, but you're not like really big yet. You're just a little guy. So you may negotiate for someone else to carry your traffic for you and make sure that that traffic is routed throughout the internet efficiently and effectively so that it reaches all of your intended end users. So that would be a transit provider. I know analogies are often imperfect, but in sort of categorizing these in my mind, I think of transit providers more like long-haul truckers, like taking goods throughout the United States, whereas broadband internet access providers, as contemplated in the 2015 rules, are more like the streets that go into your neighborhood or cul-de-sac. So that's the local network. And so at some point, if you're a startup or a company paying a transit provider to route your service, you're going to have to hand off that traffic to the last mile provider. The thing to keep in mind about most of the internet that's not last mile networks or broadband internet access, last mile is another bad term that doesn't really mean all that much, but is that there's a lot of different routes that your traffic can take to get to customers up until that last point where the broadband internet access provider is. This is why we call them an eyeball network. They have access to your eyeballs and no one else does. Because how many people here have broadband internet subscriptions at home to more than one provider right this second? Like you subscribe to both Time Warner and, well, you wouldn't, both Comcast and Charter or something. No one, right?
Or
So
Fios,
you
for that matter.
Or five, yeah.
You should qualify. How many do you have access to?
Oh yeah, well, yeah. Some of you may have no choice, but even if you had a competitive array of offerings in your neighborhood, you only purchase one subscription at once. That's why it's an eyeball network. That company has a premium access to your eyes, and so that's why we worry about the shenanigans that have led to the codified net neutrality rules, because when internet service providers have that access to you and only you, then there's a lot of incentives to manipulate traffic in such a way that allows them primarily to charge other people money to access you. And so when we're talking about interconnection, when I'm talking about interconnection, and I think when MLab was talking about interconnection, we're talking primarily about the handoff of traffic between transit providers and last mile. It is true that some internet companies are large enough that they have developed their own networks, more or less, or that they're now hosting content much closer to certain users. But that's a sort of outside the context of the type of interconnection that we've historically advocated needs oversight. Does that help?
Yeah, and I'll add, while there's been rightfully so, primarily because of a competitive setup, emphasis on video, I would actually argue that in many of these cases, video providers have a somewhat easier time simply because they can go to commercial hosting services like Akamai, for example, where I do see the more innovation potential and potential for consumer harm is for novel services that don't fit easily into the existing infrastructure, such as game services, low latency game services, specialized video conferencing services, telemedicine that would typically not use, cannot use CDNs itself, and they have to use transit. The transit landscape in general, and this was a broader discussion that easily take up the remainder of the time here, has changed significantly in the last few years, partially because the networks that we used to think of as local access networks have, just like the big Google, Facebook type networks, have developed their own networks, and many of the access networks have now national networks that they also resell. So now it is, if you're not on one of those networks, not on Comcast, not on AT&T, your choices are much more limited, given that the largest network, level 3, was just bought out by CenturyLink, so there's really only Zayo as a relatively small player, and Cogent left in the United States as an independent transit provider, and Tata and a few other international ones.
So you asked the question, how many people have multiple broadband providers at home, and I think maybe Vishal whispered something about how many options do we even have, but that was kind of a question I'm curious about. How many options do people tend to have in the US?
So I think Henning has the data on what's the level of competition in broadband access, but that is the problem. The eyeball ISPs can do these shenanigans if the customers don't have a choice. If I have an option of 5 ISPs to choose from and one of them is doing shenanigans, I can move. But that's the problem here in the US, and this problem is not, eyeball ISPs exist around the world. But the problem is accentuated here because we don't have too many options. US has become like islands of monopolies. Each ISP has carved out their own geographical area, and there's not a whole lot of competition going on in those islands. So that really is.
So roughly, what changes when people talk about competition, and this often makes the debate somewhat talking past each other, is at what layer and in what place. So generally speaking, and this is often where kind of the coastal perspective is a bit biased, is that in kind of East Coast, West Coast, with high density cities, you have up to 3, RCN being the third one in New York City available. So usually you have your telco, one cable company, like you said, there's never more than one except RCN as being kind of an oddball exception. And that's one, the telco buys and fires in New York City. In the level of competition, so if you take 25.3, which is the benchmark that is used by the FCC as high-speed internet, it's roughly speaking 50% of the population, order of magnitude, have 0 or 1 provider, and obviously the other 50% have more. Now, you have to be somewhat careful with those numbers because in many places you have a third competitor that doesn't actually exist. So there's a company called Megapath that shows up in lots of broadband maps that is actually a business provider, not a residential provider. But generally speaking, it's about half that has. And I do have to say that level of competition actually has gone up primarily because AT&T, and to some very small extent, Verizon, and to some extent specialty providers like Cincinnati Bell, have deployed more fiber to raise the level of competition, but again, half doesn't have any of that. And in smaller areas, in real rural areas, you have one provider. It's just the nature of the beast. If any, if you have any provider at all, you have, the only competition you have in that case is the satellite provider as the second provider.
And one thing I always like to point out is that while Vishal is right that competition can alleviate some of the concerns that are captured in the full suite of net neutrality concerns that we worry about. For the reasons I mentioned earlier, this gatekeeper or eyeball status that ISPs provide make the need for net neutrality protections in our as we advocate necessary, even if there is even in areas where there's competition. That is to say, there are enough constraints that on switching networks, and certainly you can't switch networks instantaneously. Like when they have to add a physical line, or tech has to come to your house. You have to pay money to shut it off. So because there's not that instantaneous switch, there still is this gateway capture to the household that exists, even if there are other options. That said, a lack of options certainly amplifies the risk of net neutrality harms, and more providers in a given area could minimize some of the concern, though not all.
And so we know that even when you have 4 competitors, such as in the airline business, that doesn't mean flying gets any more pleasant because of that.
So today the FCC classifies broadband providers as common carriers. Can someone talk about what that means and how that differs from unbundling?
Sorry, I didn't quite.
How it differs from unbundling?
Oh, so yes. And so this goes back to, we need to have talk about Title II at this point somewhere, is because that gets involved in the discussion as well. So in the mid-90s, before the internet came about, there had been and I would say largely bipartisan consensus that more competition in telecommunication was a good thing at all levels. So there had obviously been the breakup of AT&T and long distance in 1984. There had been long distance competition with Sprint and MCI and other forgotten long distance carrier names. I mean, Sprint exists obviously, but in a different model. And in 1986, there was a notion, I don't know how much influenced by the European model, but certainly, again, a largely bipartisan consensus that we needed more competition for local telephone service. Again, the internet played almost no role in the discussion, with one irrelevant exception. And so the notion was, and this goes to Vishal's discussion about competition, that there is no country in the world that has more than 2 physical wires going to a single household. That's kind of, even in dense urban areas, again, with very few exceptions, I say, with a little asterisk in it. On occasion you have 3, like RCN in that, but they have been able to do that because they have laundered themselves through a bankruptcy cycle a few times, so they've basically gotten their investors to pay for their misbegotten coax investment. But generally speaking, 2 is the best you can do, and that's generally you can divide countries into countries that have cable that have 2, and countries that don't have cable that largely have 1, fiber teleco incumbent. And so the idea was that you would have competitive local exchange carriers, CLECs, being offered a bootstrap so that they could access what were known as the unbundled network elements, which basically meant the copper loop and certain switching functions, telephone switching functions, to reach subscribers, and then they would, eventually the idea was they would then acquire enough subscribers in a particular area to build out their own network facilities. Title II of the Telecommunications Act provided mechanisms to force the incumbents, who obviously had no interest in doing that because they would be essentially providing facilities to their competitor, to provide those facilities at regulated rates, otherwise it would be meaningless. And to some limited extent that took place. Wasn't a great success, I would say, in terms of market share in that, and obviously then local telephone service became less relevant economically. So the question has always been, if we want competition in wireline services, in that the likely model is indeed forced separation of facilities or unbundling. There are multiple models there. And other countries, and this is what Vishal was referring to, generally have implemented a variation on either unbundling or what's known as structural separation, where the same company cannot provide both a physical wire or fiber and provide consumer services, or they have to provide it through independent subsidiaries like in the BT Connect and the British Telecom consumer arm in that. And so that I should emphasize, while that was one of the fears that Title II as part of the 2015 regulations would drag in, so to say, the obligation, fear by the opponents of that rule on the Commission, that this would be used by the Commission to force local providers to unbundle their network elements like it was done for voice. That obligation was explicitly forborne in the 2015 rule, so it did not apply. It didn't mean the Commission couldn't change its mind. I mean, the Commission can change its mind, as is obvious, anytime it wants to, more or less. We'll get to that more or less part later. But that has not happened. So I would say the unbundling discussion is a broader one to yield competition as probably the only wireline feasible model that at least has some demonstrated ability. Canada actually does it fairly well, I think. Unfortunately, their prices for broadband are still not all that much lower than US ones.
One point I would add, and maybe we're getting a little academic, but we're also at a university, so I would argue that the 96 Act, whose primary goal was to promote competition in a ecosystem that had been allowed to become a natural monopoly before that. One of the goals, of course, was promoting competition, but even within Title II, I would say a very important secondary goal was promoting principles of non-discrimination. It's codified in the primary, like, foundational sections of the statute. And so, and I would just emphasize, and this goes back to my previous caveat about competition, I think competition is important. I think non-discrimination principles are important, and I think the Act was designed to accomplish both. What I would argue that the 2015 rules did, and the approach the FCC took, is reclassified broadband internet access providers as Title II carriers, so they were subject to the same provisions that the phone carriers had historically been subject to, with the forbearance from the vast majority of provisions in that Act. But the reclassification and the open internet rules themselves were really grounded in that 201, 202 non-discrimination anchor. And so, that's a distinction I might make, in a legal brief or something, is like there were multiple motivations behind the 96 Act. A primary one was competition, but I'd say an equally important one was non-discrimination.
Yep.
So who put the current regulations in place and when? We've heard a few years thrown out there.
Yeah.
And I guess, Henning, this is to you. What was your particular role at the FCC during this time?
So I joined the FCC in 2010, and then there was a perceived need, and this was partially, so there was history. I will mention a little bit of history. Is often the FCC actions have been reactive to some extent, often to court losses. In particular, the 2010 was largely due to losing the Comcast case, where the commission had informal, semi-formal rules that date back to 2004, 2005, that were broad policy statements in that particular case for internet service providers. And then Comcast, the BitTorrent case came about, and Comcast sued the FCC that the FCC had insufficient legal authority to do that, which then led to the 2010 Act, which was essentially, from my perspective, when I was involved in it, there was some hope at the time that Congress would step in. Indeed, there were relatively mature discussion which failed for a variety of reasons, which I don't think are worth going into here. There's been blame going around on both sides. And there was an attempt, I would call it Clintonian, to kind of split the difference, namely to do the minimum possible to deal with Comcast-like cases of explicit blocking, Madison River, which was one of the other famous cases, voice over IP blocking, and provide some legal certainty without getting the Title II discussion going. That was certainly part, and I'm sure you advocated, your organization advocated even for Title II at that point. There were lots of organizations that basically said, this isn't going to fly legally until you do that. But there was an attempt made to find a legal justification, Section 706, which is a very broad kind of goal statement for providing much looser rules. To make a long story relatively short, Verizon sued the FCC, won largely, not completely, again on authority grounds largely, namely saying that it is insufficient to find a general Title I type of justification as a general goal in furthering broadband deployment in that, and so the rules were short, the non-blocking, non-discrimination rules and so on were invalid. And then that led relatively quickly, and again, we're talking within a year or so.
2014, I think.
Yeah.
Or no, yeah. 2010, the 2010 ruls were overturned in 2014.
Yeah. So about a year in that, and maybe even less. There was then the attempt made, and initially, again, not worth going into, there were other attempts made, and I was part of those discussions. Can we find something other than 706 that was clearly insufficient to ground rules in? And it became, I think, clear, and I wasn't part of the legal team, but it became clear that there was no real reason, no real avenue open that was not as likely to be overturned on appeal as the 2010 rules would have were in that, and so that led then to this restricted Title II or partial Title II forbearance or whatever else you want to call it model in that. And so this has always been reactive to essentially actions of the carriers in that. And we should point out, because that's often ignored by the discussion, needless to say, the FCC was sued under 2015 rules as well, and those have actually been upheld by the DC Circuit in a majority, not a unanimous, but in a majority opinion. They have been upheld as providing sufficient legal ground for the rules as promulgated.
So, Peter, since these regulations were in place in 2015, have you seen changes in how the internet is operating? And have things gotten better or worse? Because a lot of what I've heard, especially from the FCC chairman and High, is that actually the internet speeds have gotten worse over time. So.
Excellent facts and measurements. This is great. According to the measurements that Measurement Lab has, it looks like the internet has gotten steadily better ever since the rules came about. Now, it was getting a little steadily better before then. So then the question is, was it getting better enough, right? Like, it was getting a little better, but then it got better again. So then the subsequent contention that I've seen promulgated around was it was getting better before and it was getting better after, but it wasn't getting better fast enough after. So there's this gap, right? That is the right way to say it. That's not borne out by our data. If anything, our data supports, near as I can tell, and of course you can verify this for yourself, the database is open, the source code is open, please take it and see if you can. I'd love it when people do that. That's like the point of the project. It looks like it got better faster after the rules. I'm not sure, there's some arguments to be made there, but it certainly didn't get better slower. So it either kept getting better at the same rate or it got better faster. And both of those are supported in our data in various ways. So from a measurement perspective, from the perspective of Measurement Lab data, the internet got better a little bit until 2014. The slope was positive, trending upwards over time. And ever since 2015, February 2015, it got better a little bit faster. So is that statistically significant? That's a great question that I would love. What's that?
Is it causal?
And is it causal? All of these are great questions which make me a little bit uncomfortable. But the
reverse is not true. So
but the reverse is not true. And so people were claiming that there was a big gap. And that is not something we see in our data.
So generally speaking, I think the biggest predictor of improvement in speed is generally the level of competition. So what we have found, I think, is that DSL in particular actually has not gotten faster. So I'll peddle another thing that I worked on, which is actually another good report that gives a good overview of performance, is the Measurement Broadband America project that is partially using Measurement Lab facilities in that. And generally the short version is that where cable and fiber compete, both get better. Where there's largely dominant cable, there is significant improvement simply because it doesn't cost a whole lot to improve. And whereas only DSL, congestion takes over because of increasing use, and there's actually been a degradation in more rural and areas where still is broadband, but up to 98th percentile roughly, where you do have broadband, but that's actually getting significantly worse, or certainly not any faster.
What's interesting there too is what you said earlier, Henning, about the phone networks and the need for regulatory interventions to improve competition. Going into the 1996 Act. I mean, to me, that speaks for a need for not necessarily more regulations, but with the appropriateness of oversight and some engagement from the expert agency, the FCC, to improve competition in broadband networks, in addition to promoting open internet net neutrality principles. And the next part of this is probably like what's happening on December 14th, because I was going to go there. But what I want to point out, and this is very relevant to that, is that what the Commission is proposing to do next Thursday is problematic, not just because it completely removes all of the net neutrality protections put in place by the FCC in 2015. With actually, that's true. They're walking back even the transparency rules, but they are reclassifying. We don't really know quite how to frame this right now, but like they're walking back the reclassification to Title II that happened in 2015. And in so doing, they're creating a regime where there is absolutely no oversight, but they're abdicating all oversight over the internet, whether it's to promote an open internet or to promote competition in those networks, and essentially punting that decision-making and oversight to the FTC, an agency which has very questionable legal authority over any of these networks right now, pending a case at in the Ninth Circuit Court of Appeals. And they're also preempting any actions by states and localities to act in this space as well. So the worry for my organization and for many other organizations who have been in this fight for a long time is that not only are the important net neutrality rules that we think are actually functioning well, not only are they going away, but the Commission is essentially stepping back from its role as regulator in an internet-dependent space.
So I mean, it's worth pointing out that at least among OECD countries, I won't speak for every country, the US will be the only country that essentially has no regulatory activity or authority at that point over broadband internet access services. It is a clear outlier internationally in that.
American exception.
I'm sorry? Exceptionalism, yeah.
Pleasantly, to the question of causality about the internet getting improved due to network neutrality rules, one of the gold standard ways of proving causality is an ABA test, where you don't have the rules,
yeah.
you don't have the change, you make the change, and then you undo the change, and you see what happens. And so we may be about to engage in an ABA test to find out if that relationship noticed is causal, which is useful from a science perspective, but maybe not from others.
But to illustrate, Vishal can talk about that more, is that one of the difficulties in this debate has been that because the focus of advocacy organizations and industry has been so much on Title II, that essentially, since we're not talking about static industry, this is not something which is going to be exactly the same 5 years from now, for a variety of reasons, new content, new business models, and so on, that all changes, whether these are improvement in speed or supposed reduction in capital investment, are laid at the feet of what is, for most organizations, I think, a relatively small concern. I mean, we see the regulatory side because that's what we engage with. My perception is for most companies, this is not, in the internet space, this is not a day-to-day concern. They have a few people in DC that might have red badges to go to the FCC, but operationally, I don't think has had nearly as much influence as other factors, such as cord cutting, such as vertical integration, such as potential competition from wireless service providers for certain things, such as the change of a transit market. There's any number of technology changes that I think have been much more relevant to internet experience so far. So I wouldn't actually expect that this is going to be a clean A/B test.
It's not going to be a clean ABA test. That is absolutely correct. And to that lack of cleanliness, I wanted to ask a question, which, from my perspective, or my understanding, which everybody to the left of me has a better one, so this is why I ask. part of why the FCC could make principles and enforce those principles, even though that was sort of a vague thing, was because of the threat of Title II classification. And so even when we talk about rolling back to the old rules, we're talking about rolling back to the old rules kind of without that threat anymore?
I think that's a really important point, and I'll let Henning jump into and Vishal. But you know, there's often this, I think, challenging rhetoric that gets tossed around that, oh, there are like, these rules have only been in place for the last 2 years. And so before that, everything was fine. It was utopia, like it was regulatory wonderfulness. And it was only until Title II came into play that everything went...
Heavy-handed Obama administration regulation to use VFAC.
Yes. And so, what the reality has been is that we've had a regime that protects, a regulatory regime that protects net neutrality for over a decade at the FCC. And it has evolved, certainly, and as Henning sort of helpfully tracked through, but there have always been rules in place, subject maybe to a few periods of time where the rules had been thrown out and the FCC was in the process of making a new rulemaking. But that just illustrates my point and the point that Peter was making. There has always been the expectation that the Commission would uphold its regulatory duty to protect consumers by maintaining these net neutrality protections that had been so integral throughout both Republican and Democratic FCC chairs. And so what is very worrisome now is that by now completely walking back, not just from the authority that underlies the rules, but from all of the rules themselves, that the Commission is opening up the door to much more problematic experimentation among the internet service providers without much of a threat of the cop on the beat coming back on the beat as easily.
Yeah, I mean, that will clearly depend a lot on, I would say there are probably kind of 2 or 3 phases that you can see. Namely, one is it is utterly predictable that somebody will sue the FCC after Thursday, basically. I mean, that I don't have to, unfortunately, I won't get much of a bet ratio on that one. So that is predictable. So that can take anywhere up to a year between all arguments and all of it and so on. There will probably be some dispute about as to which circuit will hear it and whatever. And so I would argue that many of the companies, to take your argument, will probably be somewhat cautious during that time period not to provide additional material which makes its way into the Friends of a Court filings of that. I mean, that would just be, not that companies aren't sometimes blissfully stupid. I mean, Uber doesn't seem to worry so much as to somebody might find out, but I just don't see that any of the big ones will go out and suddenly block whatever CNN or suddenly do some other outright shenanigans. The next big step, which will obviously overlap in time, is what happens in 2018 in the congressional election. If it turns out the House flips and the Senate potentially, then I suspect there's a strong incentive for the new majority at that point to reverse the FCC actions. That won't be easy, even with a majority, for reasons I won't get into, because I don't think even the Democratic caucus is quite united on what to do. But certainly there is then an incentive, because one of the problems, and this goes into, you probably have a much better perspective of the Beltway dynamics in there, there's always been kind of, why doesn't just Congress deal with that? And that would remove a lot of the perceived uncertainty, and there was always kind of a game of expectations partially in that, namely, what can we get as a compromise within, kind of even within one party? To some extent, one party doesn't care one way, doesn't care at all, but leaving that aside. And secondly, what can we get just through the FCC and the courts? And up to very recently, and given that everybody expected the election to turn out differently, there was a notion, I think, on the Democratic side, somewhat naively, that the deal they could get at the FCC in 2015 was much better than the deal they could get in Congress. And so that there was every incentive not to offer a deal, and the dynamics are now slightly different.
So I had one follow-up question to that. You talked a little bit about what the kind of legal aspects might be going forward, and I was trying to understand what the kind of grounds for the reclassification would be. And my understanding is that the U.S. Court of Appeals upheld the current regulations, including that broadband access with a telecommunications service subject to common carrier. So what does that ruling, how does that ruling relate to the current effort to repeal, and does it not establish any sort of precedent for?
So as a general matter, a general legal matter, federal agencies have a considerable amount of discretion to, particularly when portions, so just stepping back a little bit, federal agencies like the FCC get their authority to do anything from Congress. So this 1996 act that we've talked about was an amendment to the 1934 Act, and that is the Communications Act is the statute that tells the FCC where they can act and how. The issue of, and it's the legal test is called Chevron deference. So the test in Chevron deference is there a portion of the law, is there a provision that is unclear or ambiguous? And to the extent that the agency has resolved that ambiguous part of the statute, have they done so in a reasonable manner? And so they don't have to, the court does not have to agree with the agency that it was the best option, the best way to resolve that ambiguity, just that it was reasonable. So here we have, on the issue of reclassification specifically, that is a question that has made it all the way up to the Supreme Court in a case called Brand X. And there, in a somewhat divided concurrence majority, the Supreme Court found that the agency was within their Chevron deference, within their discretion to classify broadband access as an information service. So this started the whole debate about Title I, Title II, or brought it to the legal forefront. So it is expected that if the DC Circuit decision upholding, so the DC Circuit said when they reviewed the FCC's decision to classify broadband internet access service as a Title II service, as a telecommunications service, the DC Circuit said, yes, that's within your discretion, we're following Brand X, that's good law. While the makeup of the Supreme Court has changed since Brand X, and Scalia played a notable role in that case, it is still expected that the FCC on the reclassification in 2015 would get Chevron deference for that reclassification. There are some interesting quirks about the classification back to Title I in this round, and I would prefer not to get into them here for various reasons, but that we think I think that's vulnerable. And that gets to some other more recent cases and things like that. But it is, as a general matter, it is somewhat suspicious to me that an agency would reverse course so quickly after such a long contemplation before it reclassified to Title II.
Yeah, and I'll just add to that, one of the arguments that the agency was able to make in 2015, because it changed its mind from the Brand X decision, was that they made, I think, something to do with it, but that they made a reasoned argument that the internet as it was at the time of Brand X was really much more like a portal. Some of you remember AOL and CompuServe. They had At Home was kind of a big cable company type thing, and they felt, for a variety of reasons, that people would buy at-home service because they wanted to access cable properties to some extent. That wasn't really quite true even then, but it was at least defensibly true in that. And the argument in 2015 was that the carriers had largely become pipes, as much as they don't like to be that, to content provided almost exclusively, leaving kind of affiliated content aside, almost exclusively by third parties. And so there was a reasoned decision based on the record that was made at that point. the current 2017 reclassification order makes a number of claims about the technology behavior that essentially tries to make an argument that the internet is, after all, kind of like AOL, and was used to be, and that's certainly one of the arguments that will be had, because that's a technical justification in that. Because the law, just leaving aside the classification, there is a rule that defines what a telecommunication service is, and it has a set of tests, 3 tests, I think, basically, that say, what is a telecom service and what isn't, and the argument in the new order is that that isn't, and some people on the engineering side consider those arguments somewhat vulnerable.
So I had reached out to a number of people who probably strongly argued for repealing it. Unfortunately, although they were interested in coming tonight, didn't work for them. But I just wanted to discuss some of the arguments that people have made for repeal. One that I'm curious about, so my understanding is in 2015, some small ISPs claimed that common carrier status would strain their ability to serve remote regions. And there's been a general argument that that network neutrality kind of discourages investment in infrastructure, and especially maybe in underserved regions. Have any of these concerns come to pass, and has access to internet in remote regions changed? Have the regulations had an impact one way or the other on these sorts of issues?
I will say briefly that as someone who, when I talk about being director of open internet policy, we view the open internet, the bulk of that work as not being just net neutrality, but in ensuring that Americans across the country have access to affordable, accessible, robust internet connectivity. And so this is that goal as a policy matter and as a real life getting Americans connected matter is something that's very important to me. And I grew up in Nebraska, not in rural Nebraska, but I'm very sensitive to the challenges that exist in Middle America for making sure that there is internet access and that it's comparable to the internet access that the rest of the country receives. That said, there is a reality of broadband build out that is based on rate of return calculations. Carriers will look at an area, whether it's phone carriers or now internet carriers, and say, how much will it cost me to provide all of the people in this neighborhood a service? And what is the amount of money I can get by selling them a subscription to that service? And this is oversimplifying it, but for many parts of the country, that there is just not a rate of return calculation that is enticing to companies. And so we've seen lots of different attempts to address that. And things like there are things that we haven't engaged in here that other countries have, like unbundling on the internet network side. We've also seen an influx of municipal broadband networks, communities that are sort of self-provisioning or working with private providers in the area to expand service or provide new service. And so we've seen some success there and some challenges. But that's a very different question and a very challenging one. You can have entire conferences devoted to how do we solve the broadband infrastructure problem in this country. And if net neutrality plays a part, it would only be like the smallest side conversation on a panel. And so I think it's an important conversation to have. I think if one regulatory switch, like turning Title II on or off or implementing net neutrality rules or not, was the solution to solving the rural-urban broadband divide, we would have solved the problem.
Yeah. So I'll just try to make an argument, which I think I fully agree with that contention, that it's not suddenly going to turn every small town into fiber nirvana, is that traditionally rural carriers have had 3 sources of income for telephone service, namely the subscriber revenue, like everybody else, universal service funds, government subsidies, essentially, and importantly, and this is where I don't think the argument is often made explicitly, is interconnection revenue. Mm-hmm. So a large fraction, for some carriers in particular, of interconnection revenue is of revenue for some of the rural phone carriers is by the big carriers paying what we would presumably, of rates which looked like they were frozen in amber in 1970, per minute rates of $1.50, that type of thing. That is, inter-carrier compensation reform is bringing that closer to zero, but not quite. And so a number of carriers in Europe, Etno in particular, and others here have said, hey, Google and Facebook and whoever else you like or don't like, but certainly seem to have a lot of money, they should pay, as opposed to just the taxpayer or the ratepayer or relatively poor rural subscribers that we can't really charge a whole lot more than they're paying now for DSL to build out networks. And the perception is that there is a large untapped pool of money that essentially a small provider could charge, but the rules as stipulated based on the earlier discussion would make that more difficult. That is the only logical argument that I've been able to see, that there is inter-carrier compensation is a large fraction of the revenue for voice. It's going away for other reasons, regulatory reasons, where the big companies won against the small brethren, essentially. And they hope that they can now use, essentially charge Netflix a toll to get to their rural subscribers. All I can say is good luck with that, but that's the only economic argument that I've heard. There is some compliance cost argument that is made for network measurement. I don't think that's a big deal for a variety of reasons, exemptions, and so on.
So I wanted to use this discussion about expanding access to actually move beyond the US a little bit. Vishal, this is mainly a question for you to start with, at least. So Facebook Free Basics was a program that had the stated goal of bringing internet access to regions of the world that didn't have it. And my understanding is that it used to be available in India, but no longer is. I was wondering if you could give us a little bit of kind of the background of what happened there, what the state is of net neutrality in India, and also I know that you've argued that maybe the FCC considers part of the issue and not all of it, so give a little bit of context on that and how it would be different in other places.
Sure. So I mean, we have heard a lot from the experts on what are the regulatory tools and how do you pass this law and Title II, but what confused me for the longest time is what is actually net neutrality. What do we mean by net neutrality? So I was studying this issue, and over a period of years, I sort of came to a definition of net neutrality that made sense to me, something that could be actionable by regulators. And the definition that I sort of propose, and in India the citizens movement adopted that definition, and India actually now has the strongest net neutrality regulations, and they are consistent with the definition I've been promoting. So the definition has two sort of parts, and it's all about promoting competition. And the definition says that an ISP should be QoS neutral and an ISP should be pricing neutral, in the sense that the QoS neutral part was covered by the Open Internet Order by the FCC in 2015, where an ISP is not allowed to meddle with the quality of service of any content on the internet. So it's not allowed to block, throttle, or do paid prioritization. So when you prioritize something, then you're hurting somebody else. So that part is fine, QoS neutral. The other part is it should be pricing neutral. So an ISP should not be allowed to charge different amounts of money for different content on the internet. So I'll give you an analogy for sort of both of these aspects of the net neutrality definition. Is suppose an ISP is a gas station, and the car that you're driving is the app or service that you're using on the internet. So an ISP or a gas station, they should not be allowed to charge you differently, or gas should be cheaper for a Toyota versus a Ford. That's the principle of price neutrality. It's the same gas, bandwidth is the fuel that drives these apps, you should charge it the same. So zero rating is a concept that we have heard a lot about. Facebook's Free Basics was using zero rating, where a subset of apps or content on the internet selected by Facebook, ISPs would not charge any money for that. Rest of the internet you pay per byte. So this sort of distorts the market. It has sort of bad side effects. So the Indian regulator in 2016 banned differential pricing. So they made ISPs pricing neutral. And a couple of weeks ago, the regulator, so the regulator in India has only authority on tariffs. It cannot control QoS and things like that, quality of service. So they made recommendations for the other agency to enact regulations which will make it QoS neutral as well. So the recommendations are mirroring the open internet order. So when you take these two together, pricing neutral and QoS neutral, that's when you get net neutrality. And these are sort of two simple concepts that people can understand. QoS neutral, again, if I go to a gas station, the gas station should not decide whether I get 87 octane or I get 93 octane. I should pick and choose whatever I want, and how the car uses it, that's my business. So it's all about giving the customers or the consumers choice and making the internet a level playing field.
And just to be clear, do the FCC regulations here say anything about the
Pricing?
price?
No. So that's what I've been saying, that the FCC has tackled half of the issue, but not the other half, and now even the half of the issue that has been tackled is going away. So zero rating was, FCC decided that it would look at it on a case-by-case basis, but no regulations were passed.
The Wireless Bureau released a report at the end of 2016 or the beginning of 2017, I think the end of 2016. At any rate, before the transition happened and before Chairman Pai took over, the FCC under Chairman Pai has essentially said, the Wireless Bureau looked at the whole suite of current zero rating and sponsored data options in the US and found that some of them were more problematic than others, and put that recommendation for the commission. For what it's worth, the commission basically just put that in the circular file cabinet and said this no longer applies.
And I mean, one of the hard, since we don't have somebody advocating to this, for the other side is, I'll mention that briefly, is that in free basic and as well as zero rating, there was always a tension. There was this notion, which one can't dismiss completely, hey, this was when T-Mobile started, really the first one is, T-Mobile is giving valuable service to their consumers, namely free music, and then later free video, and you want to basically, you're being the Grinch here, since this is the season, for taking that away in that, and what's the consumer benefit besides some theoretical one that is much harder to see. And in general, price discrimination is namely where you charge different people either for variations of the same product or the same product, different amounts based on the value that they place on that product. This is why we pay different prices for airline tickets. Even the same seat is not a bad thing in and of itself. In that, and this is where competition goes in. This is a much longer discussion, but I think this is one discussion where there are good economic arguments to be made. For example, there's been long discrimination against tethering, even in unlimited plans, which are not neutral by any stretch, because it's the same bits. But nobody has said much because it's pretty clear that unlimited plus tethering unlimited is a business model that is unsustainable for the carriers. So people, even on kind of what I would say, and I don't want to speak for you, but I have not heard peep on that score as that being, nobody has filed, and I know of a neutrality violation against tethering being treated differently, or even some prohibition against tethering is a different one. There was a case there, that's a different matter, but different rates that you could have was not a case.
So just wanted to give another A/B test data.
Okay.
Since the 2016 February ruling in India where they banned differential pricing, people were worried, that would stop the spread of internet amongst Indian users. So the rate of internet adoption has accelerated after that. The price of bandwidth now is a tenth of what it used to be. The speeds have increased, and everyone gets full access to the internet. There's no free basics, there's no walled garden, you don't have WhatsApp packs or Facebook packs. Everybody gets full access to the internet. So I don't know what the B there's going to be, but the A has worked out great.
Excellent. I'm glad to hear it. That was going to be my next question. We keep talking about places around the world. It's a interesting question to ask, and I have data, but I don't know exactly how to ask it because I don't know the regulations around the world. Whose regulations are the best, and can we steal them?
I'm a domestic policy advocate.
Yeah.
I mean, we've done some comparative analysis in our cost of connectivity research, but
Yeah, so there is this is a long discussion. So there is the U.S. rules have, as you hinted at, have actually had significant intellectual influence on Europe and India in particular. For some reason, Korea and Japan, I mean, China is a different matter, they have other issues, but Korea and Japan have never had much of a network neutrality discussion, but partially it's because of unbundling. There's less of an issue there. Europe has had a strong one, but there the problem that you get is, and again, this is why this discussion is difficult, is that BEREC, as kind of a common European regulatory advisory board, they don't have any authority directly themselves. They can't make rules. They can provide guidelines, and they have kind of strange enforcement abilities to make people do things. And there in Europe, you also have the European Parliament as a much stronger role to play. So, but implementation of those rules differs quite dramatically. This is where the Portugal case that you're going to bring up is going to come in. Is some countries, you could call it because of cozy relationships between a regulator and the dominant carrier, or because of different value judgments, have been far less aggressive about enforcing network neutrality rules in that. So that's a little bit of a, you have to be careful that if you say, yes, Europe actually has strong network neutrality rules in place. On the ground, the situation is a little murkier, and then that statement would indicate, and anything else would require a much more in-depth analysis.
So we've covered what the regulations are here, how we end up there, what we might see going forward, a bit about what we see around the world. I wanted to move towards taking a couple questions from the audience, but are there any last points that any of you really feel you need to get in?
I want to emphasize the importance of actually, when people say it's working well, for people checking that. The Measuring Broadband America Act, I'm super glad it exists because it specifies they have to actually measure the internet around the country and go, yeah, it's working, or no, it's not working. And that's really where the rubber, I think, hits the road in some sense, because we want it to work well for the people who are using it and for the people who could use it. And so just to circle around back to the importance of not just establishing principles, but establishing what those principles might mean and what those goals are for what we want the measurements to become over time. You said the rollout to more Indian citizens in India, and the internet's getting faster and people are investing more, and that's a super great, all those are great measurements. And so just wanted to emphasize that we hopefully eventually we always circle back to the question of how well is it actually working, and we can always answer that.
To my only, I'll make one final comment, is the one thing I would want to caution against is this monocausal type of thing. Like the only reason if you suddenly pay $5 more for your cable connection, that is because open-ended rules were abandoned, or whatever else you don't like about your cable company or your wireless company. There will be lots of attempts. This is kind of the same thing as attributing the details of the unemployment rate to the president at any given time. There will be lots of discussions where I think, particularly in an academic setting, we should just be careful that we don't. Network neutrality is clearly important. I would argue not so much, even though those are clear indicators of the precise rules. the much more important one is just the philosophical abdication of any regulatory role for that. So if the current administration, as was at least plausible given kind of the populist type of indications in the early Trump administration, that there would be a change in rules, that would be one thing. We can argue what those should be and what are good, but the abandonment of those rules leads us into a new regime that we just haven't tested out in that. But we just need to be careful not to attribute all bad things, or good things for that matter, because the likely thing that people will say that internet will still get faster, you'll probably have new internet services emerging, and people who were in favor of abandoning the rules say, see, you can still read your email, you can do whatever, because it's really hard to do a alternative, kind of what would have happened.
We don't have a control internet. We just have the one.
We can't run a kind of true path.
Did anyone come here with questions tonight they would like to answer before?
I came here thinking, my question has to do with prioritization. Am I allowed to prioritize traffic as long as I do it not based on who it's coming from? In other words, can I prioritize all my voice traffic over web traffic?
In the I there, are you I the consumer?
Or
Let's say I'm Comcast. Before I came here, I thought that I could, and now I'm not feeling like I can.
I'm sorry, I had to figure out who the hypothetical I was before I could hear the rest of what's the paid priority?
So if I'm Comcast, is it okay to prioritize all voice traffic over all web traffic? As long as I'm not prioritizing my voice traffic over someone else's voice traffic.
This came up more in the zero rating context where, and this is why some staunch net neutrality advocates were perhaps a little bit more generous with the T-Mobile differentiation of, so what T-Mobile is doing, they were basically, and the reason we didn't like it is because they're throttling, but they were essentially reducing all of certain types of content, like video content, to a lower frame rate. And then if they were doing that to all video traffic, and then if carriers if those internet video providers wanted to go into negotiations with T-Mobile, then they could say, okay, well now this isn't going to count against any of the the T-Mobile users' data caps. So that was problematic to me. I don't even know if I can speak for my whole organization on this, because I viewed that as throttling in a way that was perhaps needed some closer examination, but it was not as problematic in the general conduct evaluation sense, because no money was changing hands. It was in some ways reasonable ways to manage their network, and so it's not a super easy question in the context of zero, and where it's come up most is in zero rating, and whether or not.
So there is a strong, and this is where I think the network neutrality community has done itself sometimes no favor, because one of the arguments that is made for the abandonment is that will enable, for example, rural healthcare type of things, or telesurgery and whatever other autonomous vehicles, whatever other fancy near future things you want to talk about. And this goes to your point, is in my view, which is I don't think was ever discussed at great length at the commission, was that a regime which allowed, and I think somebody brought that up, that you can buy better service. And traditionally this was only, I can buy 25 megabits versus 10 megabits, 100 megabits, but that if you so cared to have prioritized bits for real-time services on your network, and that was a separate service that was available to all traffic. So if email is your favorite thing and you want to see that a millisecond sooner, that would be your privilege. I've had a hard time from a theoretical perspective to have much to object to that, but some network neutrality advocates clearly saw that as a slippery slope, if nothing else. Some of the non-technical ones in particular, I would argue, in that. And I don't think that was ever a major advocacy point for the other one, simply because it just hasn't come up. No service provider has actually offered that as a service that you would get. What you could do, for example, is different LTE classes that you would offer that are actually offering quality of service where it matters, where you actually have a differentiated experience. Nobody ever tried to offer those as a consumer service.
And go ahead.
So, according to the definition that I've been promoting, that would be okay, as long as every voice and every video was sort of got a fast net.
Yes, no. Is that true?
It's not true today, and the problem with T-Mobile's program was also that they were not able to identify all video and
Right.
all. So they were not doing it for all video or all streaming services. There were, niche streaming services that were not part of the program.
There
It
was
not
also some
managed-
technical compatibility
Yeah, yeah.
issues
So-
that
so I
were
mean-
challenging for small.
You had to specifically sign up for the service, or, as a provider and all that.
But if you did it for everyone, then well, they're competing evenly. That's fine.
And content neutral would be fine.
Yeah, and my understanding is based on sort of hearing about the argumentation of these in history is that part of the thing that is taken into account when assessing that is okay by regulatory agencies is why you're doing it. If you're doing it because you want to mess up all your competitors, that would probably be looked on unfavorably. If you were doing it because you wanted to provide better service because you saw old VoIP packets transiting the network and you were like, well, these would never be useful in any conversation. It's useless work on my part to carry them. Those are different conversations is my understanding, but again, others know better. Indeed. That's why people judge that's why there's whole arguments that happen.
Any other questions? No.
I have a question. So my current understanding is right now they wanted to charge YouTube or Netflix more because they're getting time to deliver a lot more bandwidth of content. That's not allowed. So I'm really good idea of kind of like the neutrality amongst quality, neutrality amongst the pricing as one of the ways to look at net neutrality. Would you see them saying to all these companies that are delivering higher amounts of or higher quantities of content to charge almost based on the amount of content? Because it's a lot harder to deliver an hour of video than an hour's worth of looking at text online. Kind of where does that fall into all of this?
So I think we're losing the audience, but you go ahead, Vishal.
So who is it okay for an ISP to charge YouTube or Netflix more, or?
Yeah, kind of based on them having to deliver a larger quantity of content.
But the ISP has sold a service to its customer.
Yeah, and it's the
customer
customer
is
requesting.
requesting Netflix. So either you don't say I'm giving you the whole internet for $60 or whatever per month. If you do that, you can't really question why your customer is getting Netflix. Right? Either you've sold that service or you're not.
So one of the issues, and again, this goes back to one, is, again, I'm trying to be as sympathetic to the carriers as I possibly can here, is, in at least presenting the argument, traditionally, the value that carriers could differentiate their service by access speed. So you would get whatever 3 megabit service, which video was probably kind of shaky, literally. You could get the 10 megabit service. It was a few years ago, all that. That service differentiation has largely disappeared in that. So the carriers are in the unfortunate situation that they need to charge everybody the same amount of money. And so that includes people who essentially have abandoned their video service, their cable video service, and watch all Netflix or other type of services, and those who only read email in that. So the two mechanisms that have been proposed both have problems, and one is capping. So you essentially create a tiered by gigabytes per month volume, so that the person who only reads email and whatever doesn't pay $80, they pay whatever, 30. And again, spreads don't exist, but leave that aside, theoretically. Because right now the problem is if you wanted to have a low usage or you are economically unable to pay 80, then your only choices are super duper internet that can stream all month or no internet. This isn't true, I'm just trying to give you a simplified argument. The other one is what you're proposing is namely that essentially you get usage charges through the back end, namely literally in that sort of case, you charge the content providers for that, and you essentially capture the value. They would in turn, this is not a freebie money, but they would in turn go out and Netflix needs to charge you $1 more to deliver the content. But then it would only hit the people who watch Netflix and not the hypothetical email user. So this is a problem in a market that is essentially unlike in the gas and electric market or water market where there's a clear metering model. Where that model hasn't worked in the internet, that is an economic problem for carriers. I'm not downplaying that, and it's not going to get any smaller. Does it justify charging for that for all the reasons that we discussed earlier? Probably not, but I admit to some sympathy there, given the constraints that they're under economic models. That they should charge less is a separate issue, but that's not under debate here.
So I think we should wrap up there, but given the interest, I think maybe we can have another event in the future when we see what has happened and look at measurements and regulations.
Yeah.
At that point. So let's all
Hopefully
thank the
not,
panelists.
right?